I would like to talk on Right to Education 2009, which was enacted in 2009 and came into force on 1st April 2010. This was inserted through Article 21A of the Constitution, making education a fundamental right for children aged 6 to 14 years, and it applies to all the schools, whether it is government aided or private, unaided, including minority institutions, though with some exceptions as per later judgments. Its objective was to ensure free and compulsory education, equity in access, and quality education standards. Main provision of the Act was Free and Compulsory Education, Section 3, Subsection 1, which says every child 6 to 14 years has the right to free and compulsory education. Section 8 and 9 says, Section 8 and 9 say duties of state and local authorities to provide schooling, teachers, infrastructure, and ensure that no child is left out. 25% reservation in private schools. Section 12 by 1 by C. Private unaided schools must admit at least 25% students from economically weaker sections, EWS, and disadvantaged groups. Reimbursement will be given to the school by the state, but reimbursement often is less than actual expenditure per child, which leads to disputes. Then comes recognition and standard, Section 18. It says that no school can operate without recognition from the competent authority, whether it is CBSE or State Board, ICSE, IB, Cambridge, CIA, whatever, Edexcel. No school can operate without recognition from the competent authority. Running an unrecognized school is punishable often with fines. Section 19 prescribes minimum norms, for example, classroom size, teacher-student ratio, infrastructure, availability of toilets, playgrounds, etc. Teachers' qualifications and deployment, Section 23, teachers must have minimum qualification as prescribed by NCTE. States must maintain a pupil-teacher ratio as per schedule of the Act. Then comes prohibition of capitation fees and screening. Section 13, it prohibits schools from charging capitation fees or conducting screening tests for admission. Violation of this leads to fines. Prohibition of physical punishment. Section 17. Corporal punishment and mental harassment are strictly prohibited. Now, what problems the schools usually face? They face the financial burden of the 25% reservation. Often, the reimbursement from the state is delayed or inadequate. Actual expenditure per child in private schools is usually higher than the state reimbursement. Often it is so. Fee regulation and capitation issues, like parents can file complaints under Section 13 alleging capitation fee even for development charges and all, IT fees or transport fees. There are some norms related to the infrastructure also. Smaller private schools face difficulty in meeting infrastructure requirements like playground, toilets, and teacher student ratio. States sometimes threaten the school with derecognition. Teachers' qualification and appointments are also a point of discussion. Non availability of qualified teachers in remote areas leads to non compliance with Section 23. Legal disputes arise in termination or recognition of teachers' qualifications. There are some points on disciplinary control also. Schools cannot expel or fail a student up to class 8. Section 16, no detention policy. In 2019, it was amended to allow examinations from 5 to 8. And this leads to indiscipline and difficulty in maintaining academic standards. Often we have conflicts with minority rights. Minority institutions protected under Article 30 have been exempted from RTE quota obligations as per Supreme Court. It creates unequal obligations between minority run and other private schools. So now comes some landmark cases and their impacts. There was a case between Society for Unaided Private Schools of Rajasthan versus Union of India 2012. Facts: private schools challenged the constitutionality of RT's 25% quota. But the judgment of Supreme Court upheld RTE, including the 25% quota, but exempted minority institution under Article 30. As an impact of this judgment, it was confirmed that RT is binding in nature on all private, unaided, non-minority schools. Another case, Avinash Mehrotra versus Union of India 2009, about fire safety in schools. There was a PIL after several fire accidents in schools, notably Kumbakonam tragedy in 2004. Supreme Court gave the judgment directing strict compliance with safety norms in all schools, including infrastructure as per RTE. So, all the schools are accountable for providing safe environment for the students. State of Tamil Nadu versus K. Shyam Sundar 2011. This was about teachers' qualifications. Questions over recruitment of teachers without minimum qualification. This was the case, matter of the case. Supreme Court gave judgment emphasizing that only teachers with NCTE prescribed qualifications should be appointed. So it strengthened Section 23 of RTE Act. Pramati Educational and Cultural Trust versus Union of India 2014. Minority institutions challenged RTE applicability. Supreme Court ruled that RTE Act does not apply to minority institutions, both aided and unaided. So it created dual compliance, minority schools exempted, others bound. In Delhi High Court, regarding reimbursement disputes 2019, Action Committee of Unaided Private Schools versus Government of Delhi, Delhi. Schools challenged delay in reimbursement under 25% EWS quota. Court directed timely reimbursement but capped at per child expenditure as notified by government. Schools continued to bear gap between actual fee and reimbursement. So RTE Act is a double-edged sword. It democratizes education and ensures access for the poor. But it places a heavy burden on private schools with unfunded mandates, infrastructure restrictions, and disputes with parents and government. So every school must maintain documentation for RTE admissions and reimbursement claims. They should also ensure that no screening or charging of capitation fee is done. They must comply with infrastructure and safety norms. Every school has the legal obligation under RTE to recruit trained teachers. Thank you.